Welcome to Ducks in a Row, the Estate Planning Guide.
Welcome to Ducks in a Row, the Estate Planning Guide with Attorney Erin Nunes, one of the managing partners at Surprenant, Beneski, and Nunes, Estate Planning and Elder Law. Erin and her team of dedicated legal professionals are helping southeastern Massachusetts families plan for tomorrow, today. I'm Lisa Mosbey, and today we're talking about what a power of attorney actually allows someone to do and why it plays such an important role in estate planning. Welcome, Erin. Thanks so much for joining me again.
Happy to be here.
Erin, what is a power of attorney and what role does it play in an estate plan?
So, a power of attorney is a document that someone can put together that empowers a trusted individual to make legal and financial decisions for them. Typically, in the event that they cannot make those decisions because of an illness or an incapacity, or if they just reach a point in their life where perhaps they have the mental capacity to make decisions, but there are maybe some physical limitations. Perhaps it's hard to get to the bank or it's difficult to sign checks, and they want to delegate that authority to someone that they trust.
And then, Erin, what types of decisions can someone actually make once they've been named under a power of attorney?
So it kind of depends. Not all powers of attorney are created equal. So the authority that someone is granted really depends on the language of the document. Oftentimes, clients will come in with old powers of attorney that they've done elsewhere, perhaps years ago. And it was more common to see a very short power of attorney, maybe 1 or 2 pages long, that grant a couple of powers, but ultimately say, this person can do anything for me that I can do for myself. And unfortunately, that doesn't cut the mustard anymore. You really need to specifically lay out the powers that you are granting to someone in order for them to have the right to make a decision regarding that particular topic.
So, in real life, what situations tend to bring a power of attorney into use?
So very often, if real estate needs to be sold, if there's a scenario where someone is perhaps transitioning out of the home into an assisted living setting or independent living or long-term care in a nursing home setting where assets need to kind of be shifted around to maintain eligibility for certain programs, or to liquidate assets so that there's money available to pay for those living arrangements, that's a common place that we see a power of attorney being incredibly helpful.
And when does it become effective? And what determines the timing on that?
So it depends on the type of power of attorney that it is. Typically, there are 2 types. There's the springing power of attorney, which you see less and less of, but the springing power of attorney does not spring into effect until you've actually lost capacity. But that can be very limiting. As I said, you may have capacity and still want someone to help you. In that case, you would need a durable power of attorney, which essentially goes into effect as soon as it's validly signed, notarized, witnessed. And then you could let your agent use it immediately if you wanted to.
And what should someone think about when choosing who to name for that role?
A lot of people ask that question, and whether geography plays a role, should they name their eldest child in the role? And really, I say, choose the person you trust to act, 1, in your best interest, and 2, who has an understanding of what your wishes are, what you're trying to accomplish as you're moving through your retirement years. Somebody who's effectively going to truly step into your shoes and act in the way that you would if you were able to make those decisions for yourself. So it doesn't have to be in order of your children's ages or the person who lives the closest to you. I mean, a lot can be done, via the computer and phone calls and things like that. So you really just want to pick the person that you trust the most to act in accordance with what your wishes are. And it's also really important that you name a backup. So in your power of attorney, you want to name your primary agent and then at least 1 alternate, especially for married couples where you would typically see them naming one another in that primary role. It could be that you're both kind of aging and having declining health together, and they may not be able to serve for you. Or God forbid, there may be a common accident where you both become incapacitated at the same time, and then that person cannot act for you. So it's really important to not just have a primary person nominated, but also at least one alternate. But you can have some layers built in there. And if you have a number of trusted individuals, it may be wise to name a couple of different alternates.
And that leads me to ask, do these documents expire, or how often do you change the power of attorney person? Is it, if it's not working out or something goes wrong, can you change them?
So, yes, you can. Under Massachusetts law, the power of attorney does not expire. Now, that in practice does not stop certain financial institutions from not wanting to accept the document once it's stale in their mind. So, if a document is older than perhaps 5 to 10 years, sometimes financial institutions don't want to accept them for fear that the document has been changed or updated and the person presenting it is not actually the power of attorney anymore. And really, the whole reason you put these documents in place is to make it easy for your loved ones. So, although they could certainly, fight the financial institution, and I think at the end of the day, they be successful in that challenge, if it made sense, every 5 years or so, even if you're not changing agents, you may just want to refresh the document to make it easier for the people that you have named in it. Now, you can also certainly change it anytime you'd like. It's a revocable document. So you can change the order of the agents. You can take people out. You can reorder individuals if you'd like to. So it is certainly changeable by the principal, by the person who's executing the document.
And Erin, are there some common problems that come up when a power of attorney is missing or maybe not set up correctly?
Absolutely. So the first scenario is what happens if you don't have a power of attorney at all and you lose capacity. Then your loved ones have to gain their authority through the probate court, and that's through a conservatorship proceeding. Conservatorship proceeding is going to run on average 4 to 6 months before someone actually gets appointed by the court as your legal representative. And, it's time consuming, it's expensive, and that would be happening at a time where you've lost capacity. And really, all they want to be doing is spending time with you, taking care of you, not jumping through legal hoops. And alternatively, if you have a power of attorney, but either the agents don't want to serve, or perhaps what they're trying to accomplish, they haven't been given the power to do, that can be very problematic and still result in needing perhaps even a limited conservatorship to accomplish that one particular thing. So, for example, if someone needed to sell real estate and that power wasn't in there, if you named your spouse and there wasn't a self-dealing clause that allowed your spouse to kind of wear two hats, the power of attorney hat and the hat as your spouse, to be able to transfer assets to themselves, which we see very often in cases where one spouse requires care. So if they don't have that self-dealing power, they can't always transfer the assets in the way that make the most sense under those specific circumstances. So again, even if you have a power of attorney, it's really critical that you from time to time have it reviewed to make sure that it is as comprehensive as you need it to be, and that it's doing everything for you that you want it to do. I've had many clients come in over the years and, we're reviewing their power of attorney with them. And I say, did you know that it limited this? Or did you know that it gave this power? And they have no recollection of that. And it's actually not consistent with what their current wishes are. So that's an opportunity where we can redo the document to make sure that it is aligning with what they want and need.
You went down in a direction about those limits. I'd like to talk about what those limits are. What can the power of attorney do that people don't realize?
So again, it really depends on the specifics of the document itself, but oftentimes we will see limitations on the amount of money that can be transferred, that they can't make transfers at all, which can be very problematic, that they don't have the authority to handle retirement plans, such as taking required minimum distributions on time. That can be very problematic. Also, not having specific language about applying for government benefits like Mass Health or other needs-based benefits programs in Massachusetts. You really need to have specific language about that. And oftentimes, when people are coming in to see us and they do have a document in place, typically it was done quite a few years ago. And it maybe was done by, a general practitioner who didn't have necessarily an awareness to all the complicating factors that can happen as you age. We make sure that our documents contemplate those things and that we are having that discussion with our clients so that we know the document is going to work if it needs to.
And Erin, I'm thinking about there's two different power of attorneys, probably more, but specifically those two are the most common. Do you have different people in charge of each of those areas? So you'd have more than one power of attorney in place?
No. So it's the primary agent who has authority over all of those things, and then the backups. In our power of attorney that we create for our clients, we do authorize the named agent to delegate that authority. So perhaps if they're going to be traveling for an extended period of time, or perhaps they're going through a medical event where they don't feel like they can have the ability and the time to manage someone else's finances, they can delegate or all of the powers or just some of the powers, and either for an extended period of time or for a limited period of time. So that can allow someone else to step in and make sure that things are being managed appropriately until that agent is able to get back up and running.
Sure. And what difference does it make for a family when that piece is clearly in place before something happens?
It's huge. I mean, no one wants to find themselves in court. Again, especially at a time where their loved one is perhaps facing medical challenges. They want to be there caring for their loved one, spending time with them. As wonderful as my staff is, we are not the people that your family wants to be spending time with at that point in your life. So having things and documents in place, a clear plan, gives such peace of mind because people are able to execute your wishes without the time, expense, emotional burden of having to go through a belabored court process.
And Erin, I want to tie this all together for our audience.
Sure.
Do you have an example of a case where having the power of attorney in place made it much easier for the family? Is there something that comes to mind?
Oh, honestly, in absolutely every case, especially our cases where we're helping our clients apply for Mass Health or Medicaid benefits. Typically, at that point, it's either a spouse or a child who is having to step in, and they may not have a full awareness of what their loved one's assets looked like. So, having a really comprehensive document that gives them access to life insurance information, retirement plan information, to gain access to tax returns. That can really help expedite that process for them and make sure that their loved one is getting the care that they need as quickly as possible, and that the Mass Health application is being processed timely enough so that they're not finding themselves having to pay $15,000 per month for long-term care costs just because they can't gain access to the information that they need. So having that power of attorney really, really helps in that scenario.
Erin, this has been great information today. Thank you so much for walking us through this document and how we use it.
Happy to do so.
That's it for today's episode of Ducks in a Row, the Estate Planning Guide. If you'd like to learn more or speak with Erin and her team, you can visit myfamilyestatePlanning.com. Thank you for listening, and don't forget to like, subscribe to the show, and share this episode if you know someone who might need it. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.